young people stay out the streets, crime don't pay. And don't be in the streets, especially if you ain't got enough money to pay for bail when the flip side comes, right? Lil Durk is locked up right now on a murder for hire charge, and his lawyer, Drew Finland, is looking to get these charges dismissed, right? He feels as though they got him on baseless, trumped up charges that shouldn't exist, right? So he's going on shows, he's doing interviews, he's talking about this, he's bringing shining light on it, right? Now they got Lil Durk locked up because they said that he hired some guys to go to California to knock Rondo, right? Now we all seen that incident that happened in West Hollywood, where they lit up the truck he was in, right? And they end up killing his cousin, Lil Pab, right? We saw that, right? It was brazen, it was broad daylight, right? And they said that they had him on like this text message, like don't book no flights or nothing using my credit card. They saying that they had lyrics from a rap song that he used, but then producers came out and said, man, them songs was old. He been made those songs. So they've been coming after him for some minute now, right? But this is what the news is reporting.
Rapper Lil Durk has been arrested and charged with a murder for hire plot. The Chicago native, whose real name is Durk Banks, was arrested in Florida by the U.S. Marshal Service. The 32-year-old's arrest comes as 5 other people in Chicago were arrested in connection with the investigation. According to the complaint, Banks and his co-conspirators allegedly worked together to, quote, track, stalk, and attempt to murder a target at a Los Angeles gas station, firing at least 18 rounds into the person's vehicle, striking and killing a passenger in the car. Banks made his first court appearance this afternoon in Miami. Banks' lawyer asked for privacy after leaving court, telling ABC, quote, we will not be commenting at this time.
His lawyer believes that they rushed to arrest him, and they didn't have all the facts in place. A lot of things is not worded right. He believes that this trial and this, they don't have these things put together right. So he's trying to move motions to get him out of jail. Right, so it says the bounty language. The indictment introductory allegations contain the following language in respect to the alleged bounty. After the murder of DB, the defendant Banks made it clear in the encoded language that he would pay bounty or monetary reward or make payment to anyone who took part in the unaliving. TB for his role in DB's unaliving indictment, right? And they say, well, who is DB? Who's TP? As to count 1, which charges Mr. Banks with conspiring to use interstate, right? So there, he's questioning the word in this stuff, right? The indictment's introductory allegation states that Mr. Banks directed actions of co-conspirators as follows. After learning of TB's location in the direction of defendants Banks, defendants Wilson, Jones, Lindley, and Houston, and co-conspirator 2 traveled from Chicago, Illinois to Los Angeles, California for the purpose of unaliving TB. As alleged in counts 1 through 3, on August 19, 2022, at the direction of defendant Banks, defendant Grants, Wilson, Jones, Lindsay, and Houston, and co-conspirator 2 used 2 vehicles to trace, stalk, and attempt to unalive TB by gunfire. With respect to count 1, conspiracy to commit unaliving for hire, the indictment alleges. As the direction of the defendants Banks, defendant Grant would procure cars, ski masks, and firearms that would be used by co-conspirators to find, track, and unalive TB, right? So this is the way that things are worded inside this, this indictment, right? The indictment is impermissibly vague. It leads the defense to guess as to the government's theory of guilt, and it leaves the government free to change that theory as its cooperative stories morph over time to meet the demands of a conviction. Because the indictment omits the factual particulars necessary to give Mr. Banks notice of the charge against him and to permit him to prepare his defense at trial, it fails to satisfy Fed-R Crim P71 in the 5th and 6th Amendments. Dismissal is warranted, right? So his lawyer's trying to get this thing thrown out. As an alternative to dismissal, this motion seeks a bill of particulars under Fed-R Crim P7 along with the 5th and 6th Amendments. Counts 1 and 2 allege that Mr. Banks conspired and and participated in a unaliving for hire. In other words, a unaliving as consideration for receipt of and consideration for the promise of agreement to pay anything of pecuniary value, or what the government calls a bounty. Defining anything pecuniary value to include anything of value in the form of money, a negotiable instrument of commercial interest, or anything else, the preliminary significance of which an economic advantage, right? So they're saying that he basically ordered the hit and was basically going to put the money up for it to get done, right? This is what the government is alleging, right? A similar deficiency plagues at the direction of language that affects every count in the indictment. While the indictment alleges that the co-conspirators carried out various acts at the direction of Mr. Banks, flying to Los Angeles, trafficking, stalking, and attempting to unalive TB by gunfire, and procuring firearms and equipment used to do so, it fails to give any specifics when, where, how, and whom did Mr. Banks give these alleged directions. To ensure the basic fairness of the trial, the defense is entitled to know, given the vagueness of the indictment's bounty at the direction of allegations, and if the indictment is permitted to stand, a bill of particulars is warranted. Mr. Banks requests a bill of particulars that reflects the theory upon which the grand jury rested its charging decision, and that gives Mr. Banks fair notice of the allegations against him. Specifically, we request the following information: the language that Mr. Banks allegedly used to convey his offer of a pecuniary bounty in exchange for an unaliving of TB, the nature of the item of pecuniary value, the monetary reward or music opportunity that Mr. Banks is alleged to have offered or delivered in exchange for the unaliving, the date, time, audience, and circumstances of the alleged bounty offer, right? The language used, the date, time, the date, time, audience, and circumstance related at the direction of the allegations in the indictment. The request is made under federal rule of criminal procedure, right? 5th and 6th Amendments. So they basically want to run down on everything so that way they can have a proper defense as to how to defend this thing. Because right now, the way that they got the language and the way they got worded, they can alter it and change it any way that they want. And they got everything, the balls in their court. So like the lawyer said, I can't defend this. The way that y'all wrote this up is illegal, right? Now, I'm not dealing with whether he's legal or whether he's guilty or not guilty. But the way that the DA has this thing, it's not done upright, right? And this is what his lawyers can. So Durk's attorney is very shrewd and very smart, right? That was the first motion. Now we go into the second motion. In the second motion, he's now saying that acting U.S. Attorney Bilal Esseley didn't even have the authority to actually bring these charges up on Durk. These charges was unconstitutional. That's what he's saying. He's saying the designation of Bilal Esseley as U.S. Attorney for the Central District of California violates appointments clause of the U.S. Constitution. Esseley lacks authority to conduct the prosecution as he was not lawfully appointed as a federal officer. Continuing to fund Esseley, who was not lawfully appointed, and his office violates the appropriations clause. Esseley does not meet the criteria to be an appropriate acting officer under the Federal Vacancies Reform Act. Esseley's service as a U.S. attorney exceeded the 120-day limit under the 28 U.S.C. 546 UT, making his actions on July 30th, that's my birthday, 2025, unlawful. The use of funds by Esseley, an improperly designated private citizen, to prosecute the case violates the appropriations clause. The indictment should be dismissed due to Esseley's lack of lawful authority. Esseley and all attorneys under his supervision or paid with misappropriated funds should be disqualified from the prosecution. So he's really coming with a curveball to get this thing thrown out. He ain't playing, man. He ain't playing. He trying to get this thrown out. The Attorney General appointed Esseley as interim U.S. Attorney General effective April 2nd, 2025, following the resignation of Martin Estrada on January 17, 2025. right? Under 28 U.S.C. 546, an interim U.S. attorney appointed by Attorney General may serve no later than 120 days after the appointment. Oh, Essie's 120-day term began April 22nd and expired July 30th, on my birthday. Public reports indicated that the judges of the district declined to make an appointment under 546, but no order or announcement was made to extend his term. Despite the expiration of his 120-day limit on July 30th, my birthday, Essie continued to serve through a series of maneuvers initiated on July 29th, a day before my birthday, 2025, including his appointment as special attorney and first assistant, followed by a purported resignation and designation as acting U.S. attorney under the Federal Vacancies Reform Act. Right, the motion argues that this 120-day limit, right, is more specific and controls over the general provisions. And since Essie's term expired on my birthday, his actions thereafter lack lawful authority. Right, so they saying that he didn't even have the authority to bring forth. He didn't even have the authority to bring forth the charges in the first place, man. Man, this thing gets crazy, man. So then we get lack of Senate confirmation. The appointments clause requires the president nominate and with the advice of consent of the Senate, appoint all officers of the United States, including U.S. attorneys. Eslie, a private citizen and political ally, was appointed by Attorney General without Senate's confirmation, which is not permitted for wielding prosecutorial power. Man, they gonna throw this case out, man. They gonna have to throw this case out. And proper acting status. Eslie does not meet the criteria under the Federal Vacancies Reform Act to serve as an acting U.S. attorney. He is neither an already in place first assistant, a state confirmed officer in another role, nor an already in place senior official in the U.S. Attorney's Office, making his actions as an active officer invalid. So they saying that he never even had the right to even bring these charges up. So this is going to get real interesting, because if they brought these charges up and this guy was not even in position to do it, man, this invalidates the whole case. Man, this throws everything. This throws a wrench in everything. You can't believe nothing they say, because they not doing everything on good standing. They already coming in lying. He's doing something he wasn't supposed to do. Man, this can ruin everything. They can throw this case out, man, all the way out the door. Man, all them dudes got to do is keep their mouth shut. They can throw this case out the door, man. This thing is real. This thing is real crazy, man. His lawyer ain't playing, man. Like, they did some real digging and found and was able to uncover this. So I don't know, man. Listen, I don't know. I don't know, man. But like I said, I thought that they had already rushed to arrest him anyway. Like, they didn't have a lot of, now, unless they got a lot of people telling. If they ain't got a lot of people telling, then they ain't, and then with this, even if they got people telling, that stuff wouldn't even be even admissible, because they was never even supposed to even bring this thing, lock nobody up or bring nobody to like the trial in the first place, because he wasn't even supposed to be in a position. He wasn't even supposed to be doing those things because he wasn't in a position to do them in the first place. I don't know, but y'all gotta let me know what y'all think, man. As more of this come out, because more of this is going to be coming out. We're gonna report more of this, but y'all gotta let me know what y'all think, man. If you made it this far in the video, hit that like button, subscribe to Street Media TV, leave your comments in the comment section. Remember, I love y'all. Till the next time, peace.